Welcome to the Business Owners Council, Legal Issues from Growth to Exit.
Welcome back to the Business Owners Council, Legal Issues from Growth to Exit. I'm Shameika Rhymes, and in each episode, we sit down with Kevin Brick, founder of Brick Business Law and trusted advisor to Florida companies, to talk through the strategies business owners need to grow, protect, and maximize the value of their businesses. Today, we're talking about what to do and what not to do in the first 72 hours after being served with a lawsuit. Welcome, Kevin.
Thank you. Good to be on here.
Glad to see you back here. Well, let's talk about that because, you just got sued. Now what? What does it actually mean to be served with a lawsuit?
Well, usually what it means in terms of what it indicates is that there's a formal legal process that's started, right? It's not just a threat anymore. So now the deadlines become critical. And if you ignore it, it could actually lead to a default judgment. So when you get served with a lawsuit physically as a business or as an individual, now it's time to start taking everything really seriously.
What are the first three things that you should do immediately?
So when you get served, you'll have an actual, likely a complaint, and the complaint sets out who the parties are, what the court is, what the factual allegations are, and usually the causes of action. So you should read the complaint, understand who's suing you, what they're alleging, the different things, and then the two parties you really want to notify. If you have an attorney, you should notify your attorney right away, and you should also notify any insurance carrier that might have coverage for it. So if you miss any deadlines, either in terms of uh, the lawsuit itself or with your insurance carrier, there could be repercussions where you lose some of your legal rights.
What are the biggest mistakes that people tend to make in the first 48 to 72 hours?
Yeah, so those first couple of days are critical. The many things you can't do. You can't ignore it or delay responding. One thing I say that you should never do is just pick up the phone and call the other party, right? That's it's a tendency that people want to do. You want to say, "Oh, I'll set the record straight. I'll call them. I'll figure it out." It's often a bad idea. You're making admissions or doing things that are going to hurt your case. Similarly, you don't want to send out emotional emails or text messages, even to your friends or your family, because those things could become discoverable evidence. So oftentimes people they lash out, they want to do something, they want to tell somebody, and what they send out actually is an admission of something. Another thing people tend to want to do is start deleting documents or altering them to help their case in some way or seemingly do it. Usually that's a terrible idea, and just the act of doing it could cause repercussions. And then, in a business, there's always this, when something comes up like this, there's a tendency to gossip, right? So you don't want to talk a lot internally about it without some controls put into place. So big picture is you want to be responsive in terms of getting with your attorney, not ignoring it, but also you don't want to be, talking to multiple people about it or sending out communications.
Would that include social media? Because I do know a lot of people run to social media after every little thing.
Yeah, that's a great point. Yeah, don't do that either.
Well, you kind of answered this one already, but should you contact the person or company that sued you?
No, I think, as I said, there's a tendency to want to try to resolve it right away, but you really lose the strategic positioning if you're making an emotional call or if you're making an immediate call without really thinking about the strategy and having your attorney handle that for you. I mean, as I said, you may unintentionally admit facts. You may say things that could be used against you. So, even if it's like somebody that you're used to doing business with, your supplier, your vendor, somebody else, now we're out of the realm of having business conversations, and now it's something that has legal repercussions.
Okay. Well, what is a litigation hold in simple terms?
Yeah, litigation hold essentially means a requirement to preserve your records. So sometimes you get this litigation hold letter that tells you you're required to preserve your records because a lawsuit may occur. But even if you don't get that letter, if you do get sued, there are things that might be in your possession that could be evidence. You still likely have a duty to preserve those things. And it gets a little more complicated in a business, because you might have normal policies about deleting records after a certain amount of time. Maybe your emails get deleted automatically. Different people hold different records in your business, very likely. So it's preserving records as part of it, but it's also maybe sending out directives to other people to preserve records. It might be stopping those document deletion policies, and you really want to be able to show a court later, just in case something ends up missing or somebody says it's missing, that you took all these immediate steps to preserve records so that it's clear that you weren't trying to hide the ball.
Well, what role does insurance play in all this?
Well, insurance, business owners and businesses themselves have various types of insurance policies. Sometimes they cover things that you don't expect or you don't really remember when you sign up for the policy. Sometimes they overlap. One thing that's consistent is they almost all always have a notice requirement, as in when you know there's a problem and there may be coverage within X number of days, you got to notify us to make sure that we provide you with coverage. And actually missing the notice can mean it can mean that you lose coverage under the terms of your policy. So keeping that in place, knowing about the notice requirements is important. Providing the notice, and then once the insurance carrier is engaged, they may either provide counsel directly for the lawsuit, or they may allow you to select counsel and they may cover it in terms of picking up the bill and those kind of things.
We talked about this a little bit earlier, but how should you communicate internally with your team? I know you mentioned the, inner office gossip type of situation, but how do you communicate with your team, I guess, when it comes to, hey, we've been sued or
Yeah.
we are suing?
Right. I mean, the first thing, as we said, you want to limit the discussions. It's got to be strategic what you decide to talk about and when. Uh, a lot of businesses will just start doing an investigation internally, asking questions, trying to find out, get to the bottom of things. It's best to involve your attorney in the decision of how and when to investigate. Um, it's when you get started with a lawsuit, especially if it's something you're not expecting, there's this tendency to have an emotional response. So it's important to just stay calm. This is another process, another thing that happens in the course of business. If you're successful, if you're running a business, it's very likely you're going to get sued. So just understand, you got to route your communication through your attorney. Don't share confidential information, and understand, when you are sending out things internally, those things might be discoverable by the other side. So you got to have a strategic mindset about really what you're doing once you're under a lawsuit.
That brings up my next question. What should you not put in writing after being sued?
Yeah, as we talked about a little bit, business records establish evidence. They are evidence, and so writing down things like admitting fault, that's one. Extremely emotional reactions is one. A big one is just trying to fix things that you think are going to be a problem, evidence that looks bad. A lot of times the cover up is worse than the crime, as they say. So if you're trying to do things to cover up or delete emails, and there's a record of deleting emails, that effort to hide it in and of itself can be damning evidence. So when you're talking about what not to do, what not to put in writing, what acts not to take, don't try to cover up the trail or put big emotional responses and things into writing.
Yeah, I can't tell you how many times I know going back to the social media example that I've seen people tagging the person or company that they're being sued by and this emotional long Facebook post. And so that's a reminder, don't do that.
Yeah, I mean the internal company ones are bad, but the public ones are worse. So
Yes.
everybody can see it.
Well, should you continue normal business operations when you're being sued?
Generally, yes. You should keep doing business as usual. Sometimes a lawsuit involves claims that might impact operations that need to be addressed immediately. So, for instance, if you have a business where you've got 100 drivers out in the field, and the claim is that you're not paying overtime, maybe, you don't want to wait till the end of the lawsuit to adjust those things. So I would say business as usual mostly, just the fact that there is a lawsuit shouldn't prevent you from running the business normally, but you should probably have discussions about the claims as they might relate to the operations of the business. If you're operating the business improperly, you need to make sure you address those things as soon as possible.
What are the key deadlines that you need to understand?
Well, when you get sued, number one, you're going to have a response deadline. It changes because by the jurisdiction. Some places it's 20 days, some places it's 21 days, but you got to know the deadline as soon as you get served. You got to know those insurance notice deadlines. And we talked about these preservation obligations. You got to understand um, evidence in your possession that may get routinely deleted. It's got to be addressed. It's got to be addressed right away. So missing those deadlines and losing or misplacing evidence, those are things you can't mess up at the outset.
Okay. Um, well, as you're dealing with those deadlines, what information should you be gathering for your lawyer?
Well, in the context of a business related lawsuit, there's oftentimes going to be contracts at issue. There might be communications like emails, text messages, as you mentioned, social media posts. A good thing to be able to put together for an attorney to get them up to speed is just like a timeline and summary of the events. Um, Key witnesses and employees who might have been involved in different things, and then policies or procedures in the business that relate to the issues in the lawsuit. So those are all kind of documents and things you can start pulling together in conjunction with your attorney to be able to get your hands around the issues.
Well, how should you think about risk at this stage?
Well, just remember when somebody files a complaint, that's their side of the story. And also that's just the beginning. That's not what the evidence says. Nobody's testified. This is just, claims written on a piece of paper. So the exposure is not always as bad as it seems. Taking things proactively early are very important. So when you're thinking about risk, you really need to get together with your attorney, look at the evidence, look at the cases, what's being claimed, all the kind of different things, and then really that's when you can really start getting a handle on risk.
What would you say are some of the biggest mindset mistakes that business owners make?
Yeah, I see three general responses when somebody gets served with a lawsuit. One is they panic. Another one is they put their head in the sand, don't do anything, denial. And another one that happens is they get overconfident. They think, oh, we're just gonna beat this thing and destroy it. But you got to take lawsuits seriously. I would say be level-headed, essentially. Don't panic. Don't bury your head in the sand, and then don't be overconfident about your chances to take it seriously.
Well, what would you say a good start in litigation looks like?
A good start to me is you met all your deadlines, you preserve the evidence, you've got your attorney engaged, everyone is on the same page. And so that means you're in lockstep in terms of determining what's going to be the response, formulating a plan about discovery and strategy, and potentially looking at settlement and different things. Um, that part feels good to me at the beginning when you kind of have your plan set out, you understand your strategy, and then you're just taking those initial steps to start working on it.
Well, I want to thank you, Kevin, for going through this process and explaining it and breaking it down. This has been so informative.
Thank you. Thanks for having me on.
If your business has been served with a lawsuit or you're trying to make sure your company is prepared before that happens, you can learn more about Kevin Brick and the team at Brick Business Law by visiting brickbusinesslaw.com. If you found this episode helpful, be sure to subscribe, leave a review, and share it with other business leaders who want to protect their companies and respond strategically when legal issues come up.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.